Hello and welcome to the LLG Grapevine podcast. You're listening to Helen Bennett, LLG's Executive Director of Policy and Governance, and Dennis Hall, LLG Bulletin Editor.
Hello, everyone.
Dennis, we got a pretty interesting High Court decision last week which impacts on remote meeting provision. It came too late in the day to make the bulletin, and it'll be picked up next week, but it's important enough for me to address today. But before I do, I understand you've been taking a look at planning law changes, some of which the new government have already made announcements on.
Well, yes, the new government have been very quick off the mark on the issue of wind energy, and changes to the planning framework were speedily announced and introduced. Here's more on this. In one of the first decisions as an administration, Keir Starmer's government has removed a de facto ban on onshore wind by placing onshore wind on the same footing as other energy developments in the National Planning Policy Framework. The change was implemented in a policy statement issued by the Ministry of Housing, Communities and Local Government, the Department for Energy Security and Net Zero, and HM Treasury, which removed footnotes 57 and 58 to paragraph 163 of the policy framework. Previously, the framework included two tests set out in the two footnotes that applied only to onshore wind, and together they said that development could only be considered acceptable in very limited circumstances. The policy statement said these policy tests will no longer apply. The removal of these tests from planning policy means that onshore wind applications will be treated in the same way as other energy development projects. The changes take effect immediately, according to the statement. Now, the government will confirm its position to Parliament on the 18th of July following the state opening of Parliament. The changes will also be reflected in the forthcoming update to the policy framework. Commenting on its wider plans to amend the policy framework, the statement added, "Through that update, we will go further and set out our proposals for wider changes to support renewable energy development. Alongside this, we will consult on bringing large onshore proposals into the nationally significant infrastructure projects regime to support quick determination, followed by a revised national policy statement." It goes on, "Local communities will play an essential part in delivering this mission, and we will empower them to participate in decisions on local infrastructure." And going further, it said, "Communities should rightly benefit from hosting local renewable energy infrastructure, and that is why we will shortly publish an update to the Community Benefits Protocol for onshore wind in England." And the policy statement comes as the Chancellor of the Exchequer, Rachel Reeves, listed a series of planning reforms, including building 1.5 million homes, reintroducing mandatory housing targets, and delivering 300 additional planning officers. And she also set out how the Housing, Communities and Local Government Secretary plans to approach called-in planning applications from now on. Helen.
Well, there's a lot in it, Dennis. We had an excellent Planning National Lead meeting last week with Gregory Jones, KC from Francis Taylor Buildings, which examined this issue in his presentation, the first 100 days of planning and the new Labour government. And I would urge all planners to watch the recording available on the resource pages of our website. Now, back to the remote meeting ruling I referenced at the start. This is the ruling in the High Court that remote hearings under the Licensing Act 2003 are indeed lawful. Quick shout out here to Stephen Turner, our licensing lead, for the quick heads up and forum notification of this judgment, which provides an excellent debrief based on Barrister Matt Lewin from Cornerstone's statement. And it reads as follows. Since 2020, the use of video conferencing technology to hold licensing hearings has become widespread. WalkSafe Security Services Limited and London Borough of Lewisham was the first case to reach the High Court in which the lawfulness of that practice was challenged. Now, the facts of the case are as follows. The appellant, the owner of South London nightclub CILEx, held a premises licence, which was revoked in late 2022 following an application for summary review by the Metropolitan Police. As it had done consistently since the onset of the pandemic, the hearing before the London Borough of Lewisham's licensing committee took place remotely using Microsoft Teams. The appellant appealed against the revocation, and amongst its grounds of appeal was a challenge to the use of remote hearing procedure. And that issue was considered as a preliminary issue by District Judge Abdul Sayed sitting at Bromley Magistrates Court. And he ruled that remote hearings were permitted under the Licensing Act and indeed the Licensing Act Hearing Regulations 2005. The appellant appealed against the District Judge's ruling to the High Court, and the appeal was heard by Justice Chamberlain in May of this year. In dismissing the appeal, the judge held that remote hearings for licensing are lawful for the following reasons. And I think it's important we examine them. So, in the absence of an express statutory definition of hearing in either the Act or the regulations, in principle, the term hearing could be applied both to an in-person hearing and a remote hearing using video conference technology. Although the regulations require a hearing to be held in a place, that word is not defined either, and nor is it accompanied by words connoting a single geographical location, unlike the provisions for ordinary local authority meetings held under the Local Government Act 72. Without such qualifying language, an online platform could properly be described as a place. And Section 9, subsection 3 of the Act and Regulation 21 of the regulations, which permit a licensing committee to regulate its own procedure, reflect an intention to confer maximum procedural flexibility, subject to any contrary provisions. So therefore, the question for the court was not whether remote hearings were permitted, but whether they were expressly prohibited. And in the court's judgment, there was no clear indication in the regulations that remote hearings were precluded. There was some discussion about the obligation to act fairly, and also in relation to the Hertfordshire judgment, the judicial review, you remember, in respect to the 72 Act interpretation, the fact that express provision for remote hearings had been made in Wales did not affect the interpretation of the Act and regulations insofar as they applied to England. So what does this mean for licensing authorities? Well, it means that they're authorised to hold licensing hearings remotely, either fully or as a hybrid procedure. And although the judgment clearly establishes the principle that remote hearings are lawful, it does contain only limited guidance on the practicalities of holding a remote hearing. So with that in mind, authorities should have a written protocol setting out criteria for holding an in-person hearing, either fully remotely or in a hybrid fashion, what constitutes valid attendance by members, parties to the hearing, officers and the public, how access to the hearing will be ensured, and any additional measures to ensure that a remote hearing will not result in unfairness to any party. Now, Matt Lewin, a member of Cornerstone Barristers licensing team, represented the London Borough of Lewisham in the High Court and the Magistrates Court, having also acted as legal advisor to the licensing committee. So, Dennis, excuse me, we now have a fragmented approach to remote hearings. School appeal panels, of course, already have specific legislation enabling remote meetings. And LLG and ADSO are writing to the Minister to raise the issue of remote hearings once again. I've said it before and I'll say it again, we're not giving up on this. Now, Dennis, what news from the Committee on Standards in Public Life?
Well, yes, Committee on Standards Chair Doug Chalmers has set out why he thinks the new government is right to establish from the outset the link between standards and public service. Here's what he said. Committee on Standards Chair Doug Chalmers has written that the days after a general election, especially when power transfers to another political party, are a hectic time in government. After campaigning hard and knocking on doors, the new teams and staffers must familiarise themselves with their new roles and departmental briefs. He said, impartial civil servants must turn and serve the new administration and be ready to deliver on their policies. Chalmers commented that last week 335 completely new MPs will arrive in Westminster to take up their seats in Parliament. And like any new job, there is always a steep learning curve, and for many it may be their first step into public life. He said, there is a unique aspect to holding public office, that of service. At its core, that means they must take decisions on behalf of the public and do so in their wider interest. But Chalmers reminds us, Lord Nolan's principles, honesty, openness, objectivity, selflessness, integrity, accountability and leadership all represent the standards that the public expects those in public life to operate by on their behalf. These principles have stood the test of time and are the bedrock of a range of rules and codes of conduct, including the Code of Conduct for MPs, owned by the House of Commons. Following these principles doesn't mean that the public will always like the decisions taken, or indeed that the decisions are actually perfect every time. But it does give public office holders and the public a framework to consider whether their decisions and conduct are taken in the public interest rather than their own. But Chalmers also reminds us of the complexity of the structure around standards and ethics. Along with the Parliamentary Commissioner for Standards, the Independent Complaints and Grievance Scheme, the Independent Parliamentary Standards Authority, and the Electoral Commission, Chalmers will also be playing a part in the induction days for the new MPs. At a time when trust in public life is so fragile, Chalmers urged all MPs to hold those principles close and seek advice from the regulators and clerks if in doubt. Indeed, most MPs undoubtedly want to do the right thing, but negative stories about a minority have done immeasurable damage to the perception of Parliament and government over the years, and this perception can be changed. And the new Prime Minister will soon issue a ministerial code clarifying the standards of conduct he expects of his team. Ministers will be expected to act in line with that code and the principles that underlie it. New ministers will already have started declaring any conflicts of interest and will be expected to resolve those, seeking advice from the independent advisor on ministers' interests. And similarly, ministers and civil servants leaving public office must protect the integrity of government by ensuring that their moves to new roles are properly risk assessed under the business appointment rules. Chalmers concluded he welcomes the new government's clear commitment to high standards in their election manifesto and the Prime Minister's statements, and the committee stands ready to play its part, helping to promote and maintain the highest standards of conduct across public life. Now, I was going to finish there, but just an update. Sir Keir Starmer has just announced that he wants to allow Sir Laurie Magnus, the independent advisor on ministers' standards, to initiate his own investigations, rather than beginning them only after a request from Number 10. You will remember this was a controversial aspect of these provisions, but critics have long believed that the independent advisor was relatively toothless because they could not look into potential wrongdoing by a minister without the Prime Minister first asking them to do so. Well, at least that's been settled. Helen.
Well, many of the committee's previous recommendations have gone unheeded or otherwise agreed and then not implemented. So let's just hope we can get some traction. Now, in other news, the ongoing rumble between the SRA and CILEx took a turn last week, with the SRA formally announcing that it wants to regulate Chartered Institute of Legal Executive members, arguing that this is in the public interest. However, the Law Society Council need to vote on it as it concerns the redelegation of CILEx's regulatory functions, and it's not a straightforward determination to make. Now, there's an excellent article in the Law Society Gazette on this by John Hyde, and that's linked in the bulletin. You might want to take a look at it. And if you think because you happen to be a solicitor, you don't need to think about this, I wouldn't be quite so sure, because this is going to require examining the Legal Services Act. Now, the Chief Executive, Ian Jeffrey, of the Law Society, has been quoted in the Law Society Gazette saying that he's deeply concerned by the SRA's move, arguing it would have a negative impact on clients, the wider public interest, and the regulatory objectives. However, the SRA maintain that 75% of CILEx members work in SRA-regulated firms and that the public supports one regulator covering both sets of professionals. If you're a CILEx member and you have concerns, please do get in touch. I would very much like to speak with you about these issues. Now, back to the election, Dennis, and the controversial issue of voter ID still abounds.
Well, yes, it does. A recent survey actually shows that the voter ID rules introduced by the last government might have stopped over 400,000 voters from taking part in the general election. Here's the detail on this. More than 400,000 people may have been prevented from voting in the general election because they lacked the necessary ID, with those from minority ethnic communities more than twice as likely to have experienced this, polling has suggested. Of those surveyed by More in Common, 3.2% said they were turned away at least once on election day, which, if reflected across the UK, would equate to more than 850,000 people. Of these, more than half said they either did not return or came back and were still unable to vote. Among people turned away at least once, about a third had ID that was not on the relatively narrow list of permitted documents. About a quarter said that the name on their ID was different to that on the electoral register, and 12% said they were told the picture on the ID did not match their appearance. Now, the poll of more than 2,000 people across Great Britain, coordinated by the campaign group Hope Not Hate, also indicated that the voter ID rules, used for the first time at a general election, disproportionately affected minority ethnic people. And it found that 6.5% of voters of colour were turned away from a polling booth at least once, compared with 2.5% of white voters. The rule that voters must show photo ID was introduced by the Conservative government as part of its 2022 Elections Act, despite minimal evidence that inter-person voter fraud was a significant problem. Before it was brought in, charities and campaigners said it was more likely to affect people from poorer or minority ethnic communities, or those with disabilities, who were less likely to have the necessary ID. And people lacking the correct ID can apply for a free document called a Voter Authority Certificate. However, take-up has been relatively low, with only about 60,000 certificates issued during the general election campaign. And another potential issue is people deciding not to vote or even register to vote because they know they lack ID. The polling found that 6% of people said the ID requirements had affected their decision on whether or not to vote, and that they then did not vote, which, if reflected nationally, could mean up to 2.8 million people not voting when they might otherwise have done. Georgie Laming of Hope Not Hate said, "This was a generation-defining election, and yet hundreds of thousands of voters were shut out from voting because of confusing and unnecessary voter ID laws. This general election was the first under new photo ID rules, and it must be the last." Helen.
Interesting, Dennis. I'm not going to try and work out the percentage of eligible votes that represents, but one case is one case too many, of course, nevertheless. Now, finally from me, the local government social care ombudsman has this month published its report on severe maladministration, key lessons and what can be learned. These centre on landlord cases for both local authority and housing associations. And the Ombudsman states that the themes in the report are clear and range from poor diagnosis, excessive delays, and a failure to consider individual circumstances, especially where vulnerabilities are present. Repairs and AWAB's law feature heavily. Now, the Ombudsman made 9 findings of severe maladministration for how landlords have handled leaks, with issues ranging from residents with water pouring down their walls to being decanted for over 2 years due to the widespread issues. Key learning identified by the Ombudsman includes the following. Anytime that a resident chases for an update, it should be of concern to the landlord that it is not appropriately keeping that resident informed about what is happening with their home. Temporary decants should be considered. Further, ultimately, a landlord is responsible for the services provided by its contractors, and the landlord's processes in this regard are poor where failure is found and contributes largely to the unacceptable delays experienced by residents. Landlords need to be clear with residents about the timescales for works, and proactive inspections and communications are vital during any leak case and when there is a child involved. Mention of health implications from an issue in a home should kickstart a more urgent response. Now, this report is linked in the bulletin, and there are plenty of lessons to be learned within it. And on that note, you can read more on the items discussed today and many more besides by going to bulletin number 17, available on the LLG website now. So it's goodbye from me.
And from me too.
Have a good week.